I also, as well as the introduction to the week video this week, I've also done a video for you on intellectual property. So why is that? Well, intellectual property in a course like this is really important because if you were to breach intellectual property, that would be a case of academic dishonesty, and as you know, the university takes that very seriously. So in this module, you must be very careful not to breach copyright law, or in fact any other kind of intellectual property law. But copyright law is the one that you're most likely to breach. In particular, you must be able to say where all graphics and audio assets come from and show that you have the right to use them. So that means knowing exactly what the copyright is on those graphics and knowing that they're free to use if they are. If they're not, showing that you have the right to use them from whoever the creator is. So copyright under UK law relates to various different things. So there's what we call literary copyright. That's most things that are written down. People think of that, they tend to think of things like newspapers and books, but also appears to things like song lyrics, articles, and in fact computer programs can fall under literary copyright law. Try saying that quickly. There's also dramatic, so that's something that's a play or a dance. Musical, so that's recordings and scores. Artistic, photography, painting, sculpture, things like maps, logos fall under artistic license. Sound recordings, which may be recordings of other copyright work in particular. So for example, if you've got song lyrics and you've got the score and you make a recording of it, that itself becomes copyright. Video footage, films and broadcast and cable programs also fall under copyright law within the UK. How long does it last? Well, literary, dramatic, musical and artistic works are 70 years from the death of the author. Lots of people get this wrong. I think it's from the birth of the author, but in the main, it's 70 years from the death of the author. There's one notable exception here that I'll mention because you could just about fall into it with your games, which is the work of J.M. Barrie, in particular Peter Pan, is still under copyright. I'm not actually sure if J.M. Barrie's been dead for more than 70 years. I think he probably has been. But it is still under copyright. It's under copyright under a very special case in UK law because Great Ormond Street Hospital own the rights to Peter Pan. And so a law was passed to make sure that the hospital could continue to make money from that. So Peter Pan is still under copyright. If you want to do a game based on a literary work, in the main, if it's not Peter Pan, if the author died more than 70 years ago, you're good to go. So things like Dracula, for example, are no longer under copyright. Sound recordings and broadcasts were 50 years, but relatively recently have become 70 years as well. 70 years for films from the end of the year the film was first made available. So that's not when the film was actually shot or video, it's when it was first made available in the UK. Broadcast and cable programs are currently 50 years. There is thought that that might go up to 70 years eventually, but it's 50 years as it stands. What is a breach? Well, it's an offence to perform any of the following acts without consent of the owner. Copying the work. That's what people think of first and foremost when it comes to copyright, is copying the work. It's definitely a breach to copy the work. It's a breach to rent, lend, or issue copies of the work to the public. Libraries, for example, have to have a very special licence to be allowed to lend work to the public. I don't know if you knew that, they do. It's an offence to perform, broadcast, or show the work in public as well. And it's also an offence to adapt the work. Now, this is where the lines get a bit grey, because what does adapting mean and when is it parodying, and it's very difficult. What does that mean for computer games? Well, making an unauthorised copy of a game and selling it is quite clearly infringement. So if you've got a copy of Call of Duty Black Ops and you make a copy and you sell it to your friend, you're breaking the law. I think that's fairly straightforward. Making a backup copy of a game you own and a license to is actually not an infringement as long as you keep that copy within your own house and only use one at a time. However, if you were then to distribute it again, it falls under the first of these, and therefore that is against the law. Copying significant elements of the source code of the game is also definitely infringement, even if the game looked completely different. Because source code and not program comes under literary law, if you copy that, that is an infringement. Some things are a bit grayer, so copying major elements of a GUI could technically be infringement of design, but so far it hasn't been. Making a game that reuses a general game idea that's already copyrighted is not an infringement. You are allowed to reuse game mechanics. Copying art or audio directly from a game is an infringement. So you can't just lift sprites out of a game and use them within your own, for example. We always think of intellectual property as being the enemy. It's the thing that stops our creative freedom. But in actual fact, for you guys, it's probably a really good thing that we have intellectual property. Because as well as you not breaching other people's intellectual property, it gives you some control on your game. So when you create your game, you can protect it using intellectual property. People can't copy you. So there's 3 kinds of intellectual property in the main. There's copyright, patent, and design, and I've also got trademark there. It's kind of arguable if that's a bit of IP or not, but we'll talk about it anyway. So copyright. You automatically get copyright protection when you create an original literary work, a non-literally written work, so that includes software, web content, and databases. Anything that you type is classified under that. Sound and music recordings, film and television recordings, broadcasts, or the layout of published editions of written dramatic and musical works. So whenever you create those, whenever you write some code, you have the copyright on that code. If you want to, you can mark your work with the copyright symbol, your name, and the year of creation. Whether you mark the work or not actually has no effect, but you can do it just to show people it's copyright if you wish. Your work could be protected by copyright in other countries out with the UK. This is usually done through international agreements such as the Berne Convention. They may hold in some countries and they may not in others, so it's worth being aware of that. In most countries, copyright lasts a minimum of life plus 50 years for most types of written artistic works. I'll say at least 25 years for photographs. It differs a lot from country to country. And it also can be different for other types of work. So it's really important to you, if you say you're making a game that you think you're going to market in the UK and Sweden because you're Swedish, make sure you understand Swedish copyright law as well. Design. So you can register the look of a product you've designed to stop people copying or stealing it. What does that mean? Well, it's the look of your design, and it includes the appearance, the physical shape, the configuration or how the different parts are put together, and also any decoration. So for example, if you were going to create a character for your game, then you could ask for a design protection on that. And what you'd have to do is create a sheet that contained the appearance, physical shape, and decoration and configurations of that main character. So if you register a design, it protects any aspects of your design. It gives you exclusive rights to that design, so to that character, for example, for 25 years. It makes taking legal action on infringement and copying a little bit more straightforward, because it's fairly clear you own the registered thing here now. And once it's registered, you can display your registration number on your design to say, I own this character, you can't copy this character. You do have to apply to register a design, and it does cost £50. If this is something that interests you, then I suggest you will look at this UK website. Some other IP types, so trademark. You might want to trademark your game name or a logo. The only things you really trademark currently are things like names and logos. So for example, if you were McDonald's, you'd have the name McDonald's trademarked, and you might have the golden M as your logo trademarked. It currently costs £170 to trademark. Patents, a lot more complex. They usually require a patent lawyer to do. The cost is approximately £230 without legal fees in the UK currently. I'm saying approximately because there's lots of different steps to the patent process, and I think that's about what it adds up to, but it could be a lot more than that. And I have to say the legal fees are going to be quite a bit more than that. So patents are a really expensive option, and you're unlikely to want to do that for your game. But just to make sure you're aware, it does exist as an option.